colleague, Mr. Mutuma, will use 5 minutes. Let me go straight to the point. But let me begin by asserting that it is sound principle in constitutional interpretation that a constitution must be read as a whole. Let me just begin by asserting that as a principle and make the following then statements of rejoinder. It has been said that what is at issue here is the sovereign power of the people of Meru. Let me summarize that as the issue. To that, we respond as follows: that it is true that all sovereign power first belongs to the people of Kenya, with a rider that it shall be exercised only in accordance with this constitution. Only in accordance with this constitution. The petitioner is telling you that this rider has been violated. That's what the petitioner is telling you. This rider has been violated. That this power has been exercised in violation of this constitution. Yes. The second issue that has arisen is that the petitioner has no, may I call it, private or proprietary interest in the office of governor. A submission was made to that effect.
Yes.
Again, let me read Article 38, Clause 3, Paragraph C of the Constitution. Article 38, Paragraph 3, Article 38, Clause 3, Paragraph C. It says, every adult citizen has the right, without an or office of a political party of which is a member, and I have a constitutional entitlement to hold office unless I am constitutionally removed. And he's saying the removal here is unconstitutional. We are making an argument, my lord. Whether or not it was or it was not constitutional is a matter for trial in the main petition. But we are saying, in the meantime, let us stop disturbing the status quo. Let us hold matters as they are. I'll address you on this issue of status quo because it's an issue by my colleagues on the other side shortly.
Yes.
Number 3, again, my learned colleague for the third interested party iterated the issue of joinder of the speaker and the speaker having no voting at paragraph 57 of the judgment in the case of the Speaker of the National Assembly versus the Center for Rights, Education and Awareness. Where paragraph 57. Paradoxically, the argument was precisely the same argument. It went, I would read it, my lord, without asking you to regurgitate it, just for a full tenor. The appellant, understandably, as we do here, protests that the Speaker has no role in initiating bills and does not even possess a vote in support of or opposition to a bill. And for that reason, he cannot be sued by the failure by Parliament to discharge a constitutional mandate to pass legislation. Same thing here. The Speaker does not bring the motion, does not vote on it, and therefore, what does the Court of Appeal answer? The Court of Appeal answers, in our view, where it is alleged that the National Assembly or the Senate has violated the Constitution, the Speaker is a proper respondent for the following reasons. Then from paragraph 58 through 59, reasons are given. Same argument, same principle. My colleague says he wants to distinguish. How? The Court of Appeal is saying, in our view, where it is alleged that the National Assembly or the Senate has violated the Constitution, the Speaker is a proper respondent. The petitioner is saying, in relation to her, the Senate has violated the Constitution. The Court of Appeal is answering, the correct respondent is the Speaker. And let me ask my colleagues the question I've asked other colleagues before. Let's assume they are right. And you are sitting there, my lord, with a court of appeal decision in front of you as well. What do they want you to do? What do they possibly want you to do? I think sometimes, as Jesus Christ said, it is written that they shall not put me to temptation or something like that. What do they want you to do, possibly? Having said that, let me move to another argument. The question is, what is the status quo? And before I go to that, my lord, allow me to finish that point of joinder. Let me just finish that point of joinder before I go to that point.
Yes.
What is the prejudice that the respondent in this matter has possibly suffered by joinder of the speaker? We submit none. For example, the replying affidavit to the application for conservatory orders and to the main petition was prepared and sworn by Mr. Jeremiah Nyegenye, clerk of the Senate. Meaning, the respondent clearly understood that he was sued on behalf of the Senate, and that's why he chose a competent officer of the Senate to prepare the affidavit and file it. I want to finish that point by saying that that repeated argument has no justicial priorities.
Yes.
I had made out an argument now that of August 2021, the Senate passed a resolution to remove the governor of Meru from office by impeachment.
Yes.
It is also true that under Article number 23, Clause 3, Paragraph C of the Constitution, this court has constitutional power to issue a conservatory order. And therefore, these two powers were exercised. Parliament exercised its power under Article 181. Court exercised its power on 21st of August 2024 under Article 23(3)(c). The proper question then is this: these two powers having been exercised by these constitutional institutions, what is the status quo? And the answer becomes, the status quo pursuant to the conservatory order issued by this court is what we call the status quo ante, the status quo preceding that action of the Senate. So what is that status quo? Honorable Kawira Mwangaza'S was and remains the governor of Meru County. It has been alleged that there was material non-disclosure, or that this court was misled in making the conservatory order of 21st of August. First, my lord, you know, in my other word, I'm a teacher. And I get disturbed a little when things are made that disturb my intellect.
Yes.
The order from the High Court in Meru was produced and attached to the petitioner's affidavit as Annexure KM3. It was produced and given to you.
Yes.
There is a strong presumption that you read that order yourself, given to you, and issued an order. How can the petitioner, who has presented the full ruling of the court, be accused of material non-disclosure? I kept telling my colleague, Mr. Mutuma, I need new schooling on non-disclosure. There can be no better disclosure than actually presenting the physical copy of the ruling for the court to read by itself. Let me then get to the second limb of this argument. The court in Meru began by framing the issue before it. Then it gave an order. Let's see the issue as framed and the order as given. When you look at annexure KM3, at paragraph 1, the court said, this court I hope my few minutes are frozen.
Yes.
Thank you so much.
This is begins at page 9.
Correct.
Yes, I'm there.
That ruling. If you can paragraph, it says, this court has to make a decision as to whether to grant interim orders or preserve a status quo or not. So the issue before the court is not limited to a particular motion. The issue is whether to preserve or not. Then, if you got now page 12, which is now page 4 of the ruling.
Yes.
Page 4 of the ruling, the court then makes the order. The upshot of the above is that the impeachment process is halted, not the impeachment motion. The impeachment process is halted. The court is saying, I'm halting the process to preserve the status quo. How can my colleagues say that this was not an order before this court? While at it, if you look at the supplementary affidavit of the governor, both at paragraph 8 of that affidavit and annexure BKM2 to that supplementary affidavit.
Yes.
The moment the county assembly approved the impeachment motion, learned counsel for the governor, Mr. Mutuma, wrote to the Speaker of the Senate, drawing the Speaker's attention to this court order.
Yes.
The letter you'll see on the face of it is stamped by the Speaker, who is the respondent, and stamped by the clerk, who is the deponent of the affidavit of the respondent. My Lord, how can my learned colleague make an argument that the Speaker was not a party to that suit? Doesn't the Speaker of the National Assembly have an obligation under Article... My apologies, the Speaker of the Senate, yes, have an obligation under Articles 10 of the Constitution to uphold the national value of the rule of law by virtue of his office? How can a Speaker who knows of a court order, as was done in this case, and continues to allow debate in violation of that court order, come and claim I was not a party to those proceedings? I mean, that is bad governance in a class of its own. It is good governance topsy-turvy. It should not have been done in the Senate. It was done. It should not have been done in this court by officers of this court. They must join us in frowning upon this conduct of these two officers, because our own oath of office as advocates gives us obligations beyond our clients, which is an obligation to uphold the rule of law. So, my Lord, you will see at a second level the response by the governor. In response to the motion at the Senate, she made that claim that there are pending court orders. You'll see the debate by Senator Halwale in the proceedings of the Senate. He asked the Speaker to consider that all those things are in the affidavit in support of the main petition. And therefore, anyone to argue that there was no court order, that is not being very candid with this court. And that should be frank.
For the completeness of my record.
Yes.
The ruling, let's bring it back up. The ruling dated 24th of July 2024 by my brother Kassan J.
Yes.
It concludes,
Yes.
this is page 12 of your bundle.
Yes.
The upshot of the above is that the impeachment process is halted.
Yes.
Pending my ruling.
Yes.
And since this is a matter of public interest,
Yes.
the rulings into brackets,
Yes.
PO, interested parties and main petition will
Yes.
be delivered on Monday, the 29th day of July 2024.
Yes.
By email to all
Parties, yes.
Was this ruling delivered?
No, it wasn't delivered. In fact, the judge recused himself from the matter before the ruling was delivered, and the ruling was subsequently delivered by your brother, Justice Muridhi, long after this impeachment process, dismissing the PO. My lord, I don't know. Just check the page after that ruling. Is there an order of court dated 29th July?
I have an amended order.
Order, yes, that one. That's what transpired on the 29th. Whatever you see there is what transpired on the 29th. Yes.
J dismissing the PO.
Yes. And you'll notice that the ruling was deferred to 20th August by Order 5.
Mr. Ngoya, is that ruling dismissing the PO, is it before me?
No, it is not. It happened quite recently. Long after this petition was filed. I'm just trying to remember the day, but it's a much subsequent development, long after we filed this petition, this application. I just answered it because, my lord, you raised it.
Okay, would you have an objection to the petition of filing that ruling so that I can see it? In reality, I can obtain it, but that is not the proper way of doing it. It should be placed properly because there's been a lot of reference to that process and what it is. Should we have that ruling before this court?
I will not object to that. I will not have
Correct.
just
Yes.
No problem.
No argument.
No arguments. Yes.
You don't even need to put it in an affidavit.
Yes.
You just file it in CTS.
Correct.
And you serve your counterparts electronically.
Correct.
Don't worry, your time had been
Frozen.
frozen.
Yes. Allow me just to submit on the question of prejudice, because that again has been raised. And if you look at the Munya decision, which is, I think, to my mind, the locus classicus on the question of conservatory orders.
Yes.
The Supreme Court gives us guidelines on granting conservatory orders. We must look at the impact of the decision beyond the petitioner. That's essentially what the Supreme Court is telling us.
Yes.
And let's just try to reflect on this, the legal consequences of not preserving this conservatory order. Article 179, clause 9.
Yes.
Article 179, clause 7 of the Constitution says, if a vacancy arises in the office of the county governor, the members of the county executive committee appointed under clause 2B cease to hold office. So this is a legal consequence. When my colleagues say they can continue, how? The law says they must stop holding office. Let's try to think about the public interest on this, my lord. It will mean
Yes.
the deputy governor, once sworn in, then must appoint new CECs, because those others stopped holding office by operation of law. It's not a discretion on the part of the governor. Hiring those new CECs means, my lord, taking them through the vetting process at the taxpayer's expense, the approval process at the taxpayer's expense.
Yes.
It means replacing now the deputy governor, because the deputy governor has assumed the office of governor. It means replacing a deputy governor now at the taxpayer's expense. When my colleague keeps saying the governor can be compensated, who will compensate these taxpayers? This is irreparable damage, my lord. This is I've never seen more irreparable damage than that.
Yes.
They will come into office, they will be entitled to the usual things, medical cover, their mortgages and grants, if any, provided by SRC. These are all consequences. So that if you eventually return the governor to office, it also follows that that deputy governor who assumed the office of a governor has vacated office. Those CECs also vacate office. The governor again begins another process of hiring CECs and other senior bureaucrats.
Just a moment.
I'm just looking at the legal consequences only.
Just a moment.
Yes, I appreciate.
So if these conservatory orders were lifted,
Yes,
and then the petition succeeds,
yes,
there would be need in the orders for the CEC members
Yes.
who have come in
yes,
to be removed,
correct,
the new DG
yes,
to be removed,
correct,
and the status quo ante
Correct.
to be re-established.
Correct.
That is your submission.
That's my submission. And I'm just saying by operation of law. There's no discretion. Because my colleagues kept saying that who said he must remove the CEC. The law itself says once this one leaves office, those CECs leave office. They can only come back to office by reappointment. And my lord, when you begin reappointing, it's a fresh appointment. It's like the other day, my lord, when the president removed CSS from office, and now I'm just giving I'm just giving an example. I'm giving a matter in the notorious. Apologies. Okay, I'll leave it at that. But I'm saying by operation of law, Article 179(7), they must go, then get appointed or fresh ones appointed by the DG who assumes the governor. Then assume the petition succeeds. Those ones whom the DG had appointed must also go by operation of law, Article 179(7). Then the governor returns to office and begins another appointment process. I'm making out a simple argument, my lord. This is overwhelming expense to an already burdened taxpayer in Meru, like all of us.
Yes.
Compare that, my lord, to a matter that is within our control completely, where we can break our backs in this court and say in the next 1 month, in the next 2 months, we must finish hearing this petition so that the chips fall into their place. This is a very proportionate way of use of power. We finish these matters, the chips fall in their place. If the governor is going, as is why the young people tell him in the streets, anaenda akiendanga. She has lost, she now goes completely. If she's remaining, she remains. That is more within our control. It saves the taxpayer, the public significantly. I urge.
5 minutes.
Thank you so much. I want to rest at that and invite my learned colleague, Mr. Mutuma, to then use the 5 minutes to make the argument I wanted to make.